Good afternoon, dear colleagues. I think I'll ask the speakers to take to the stage Mr. Roman Kuibeda, the deputy head of the Center for Political Legal Reform, as well as our Dutch expert, where we had the expert and the opportunity to Mr. Silk to learn from the Dutch experience and to learn from the Dutch experience and why the level of confidence in Dutch courts is so high, and what impacted this high level of confidence, and how can you bring the Ukrainian level of confidence in courts to the Dutch level. We're still trying to get in touch with Mr. Borowinsky, who had previously confirmed his participation in the panel. We're hoping he's doing fine and will join us in due time. He is the co-head of the Presidential Commission on Legal Reform, and today we'll be talking about the judicial reform and about restoring trust in courts. I think it is very symbolic that we've planned this event a while ago, and now the Parliament passed in the first reading Draft Law 1008 on the judicial reform, and all draft law is authored by the President. So maybe we'll talk about the draft law as well. Now I'd like to give the floor to Mr. Roman Kuibeda, who performed the bulk of the work in drafting the report, where we compared the factors affecting confidence in courts in the Netherlands. And thank you. So, talking about confidence, talking about trust, these matters are highly subjective, but if we unite all of our ideas and we look at the results of sociological study, we can see an objective indicator, we can see an assessment of how the judiciary functions in regard, or how the state functions if we're talking about confidence in the courts and the state respectively. There are different types of societies in the world, societies with high and low levels of confidence in authorities, and Ukraine is part of the latter. It's a society with a low level of confidence in the authorities, and this level of confidence is low and remains low. Has been low for a long time. We could observe the dynamics of change in trust levels towards various institutions. I have only looked at the Parliament, the government, and the President, as well as courts. You see these graphs show that the level of trust, so the political trust towards political bodies depends on the elections. It grows after the election, and before the election it falls to a critical low. And regarding trust towards courts, it doesn't fluctuate that much. Normally this confidence level is stable. This is not only a Ukrainian phenomenon, the same applies, the situation is similar in countries across the world. There is, however, a key difference, and the difference is that in many developed states, the level of confidence in courts is higher than the level of confidence in political institutions, whereas in Ukraine, the courts are trailing behind political institutions, and the levels of trust in the two bodies equalizes around the time of the election. Now we're seeing a situation that might in the future be described as phenomenal, whereby the level of confidence in the President, the Parliament, and the government has grown to a phenomenal level as of September 2019. And we can also see a slight increase in the confidence in courts. So normally this level of confidence appears stable. In order to affect this level of confidence, we must make a serious undertaking to dramatically change the situation, to overcome the Ukrainian tragedy of courts trailing behind in the level of popular trust. If you compare Ukraine and the Netherlands, we chose the Netherlands because because The Hague is renowned as the international capital of justice. A lot of the judicial institutions of the world are in The Hague. Holland enjoys a very high level of trust in the courts, and of course the history of both countries is very different, and it was quite hard for us to compare what we saw there with the realities on the ground. We have a lot of new instruments used in Ukraine that are not yet used in the Netherlands. For example, automated assignment of cases, or a developed scale of disciplinary penalties, and so on. These are things we weren't able to see in Holland, but in Holland there is also no need for these cutting-edge measures because the court system has been functioning for many decades, maybe even centuries, and it has over time enjoyed a high level of success. We could see the dark bar is Ukraine and trust towards institution. I don't think it shows what institutions exactly are measured, but I can say that we can find courts here at the bottom. This is the data as of 2018. It's a 7% confidence and trust in courts, and A compared to 80% in the Netherlands. And if you look at the army and the police and the other institutions, confidence in the army is relatively high. In Ukraine, it is the most trusted political institution in Ukraine, or it was the most trusted political institution before the 2019 elections. We have tried to break our study down into 3 components, so personnel and sadly the human resources policy was failed in the court system, also the service orientation of court. And this is what markedly sets Dutch courts from Ukrainian courts aside, and also the matter of communication. Regarding personnel, according to the study of 2015 and 2015, the tip of the iceberg, the most problematic issue remains the same. It is the prevalence of corruption among judges. It is the issue of judges' dependence on oligarchs and politicians, as well as complete markup in the judicial system, and mutual cover-up in the judicial system. And all of these things are one way or another connected with the topic of integrity. You can see that a low level of professionalism marked by it's not about, so people decided that a low level of professionalism is less of a hindrance, less of an obstacle than a lack of integrity and dishonesty. The court reform initiated by President Poroshenko strove to increase the independence of the judges, and strides have been made in this direction. Constitutional changes have technically decreased the ability of political bodies to influence courts, and as well as the introduction of a qualification assurance system for judges. And what we saw on behalf of the courts and the judges is that the individual's impression and level of trust in the court mostly depends on the activity of the judges. So you can see that both these bars mark impact, so the red bar marks negative impact. People think that the activity of the judges has the most negative impact on the judiciary. At the same time, the activity of judges also has an opportunity to positively affect the level of confidence in the courts, and that means that it is the judges who have the key to get through to the citizens and to demonstrate palpable change. It is not up to law enforcement organizations, international organizations, politicians, or NGOs that influence the level of trust in courts, but the judges. Let's look at the results of the qualification study performed by the highest qualification committee and the Higher Council of Justice, that rules on the removal of judges as per the result of this study. We have assessed about 3,000 judges that have passed. That's over half of the judge corps. As a result of the assessment, 27 judges have been fired, fewer than 1%. And let's look at the judges who have been fired. Of the 27 judges, 18 failed the exam. The qualification assessment is comprised of an exam, so an assessment of knowledge and the ability to apply this knowledge, and the interview. And the interview that can really show whether or not a judge is honest and follows the principles of integrity. So 18 judges failed the exam. 8 failed to show up for the exam. These are judges mostly from Crimea or the Donbass who decided to avoid the exam, and some of them are serving as judges in the so-called courts of the DNR or the LNR. And look at the last figure. Only one judge was fired as a result of the interview. So the higher Council of Justice agreed to remove one judge as a result of a failed interview. Some of the judges who have failed the assessment, 170 judges have failed the assessment, are removed from office with a pension for life. They have resigned with a pension for life, and during the previous session we saw that the disciplinary body is also controversial, and the higher Council of Justice is the disciplinary body which can affect the fates of judges. And if a judge demonstrates independence, he could be persecuted. If the judge follows the informal rules, the higher Council of Judge will do him no harm despite the lack of a social demand for genuine justice. So dishonesty in courts is something that leads to dependence. It is easy to keep a dishonest judge in check. The results of the analysis and the results of our interviews with our Dutch partners demonstrate that judge selection bodies should include more agents of change, people society trusts. In the Dutch example, you could look at the National Judge Selection Committee, and when we were in Holland, a pastor and a film director were members of this committee. They can hardly be called legal experts, but their role is to legitimize the results of the judge selection procedure in the eyes of society. This formula of judges being chosen by judges as recommended by the Council of Europe has had a negative effect. In fact, it has led to a conservation of the negative aspects of the judiciary in Ukraine. The higher Council of Justice, instead of being a driver of the reform, have in fact acted to preserve the negative elements of the system. The Constitution defined the requirements for judges. They are competency, integrity, and compliance with professional ethics criteria. Sadly, the latter two criteria are not verified during the primary assignment of a judge, so it is about checking a judge's level of knowledge and not about verifying the candidate's previous activity as a judge. This only pertains to the level of local judges. During competition in the Supreme Court on the higher anti-corruption court, these criteria were taken into account. Another thing that fascinated us was the conclusion of one of the Dutch judges that Ukrainian judges are legalists. They need instructions, but they are wary to use categories such as the principles and values of justice. this legalistic approach is incompatible with being guided by principles and values. The training of judges in Ukraine fosters this legalistic approach. Judges train to get a clear step-by-step guide on how they should act. They want to get a clear instruction manual instead of developing their critical thinking skills and their skills in motivating verdicts based on certain values and principles. One of our recommendation has to do with shifting the training to teaching judges to use principles and values when motivating their verdict. A judge's integrity isn't something that should be imposed, but it should be, much like independence, the judge's independent position. Independence is something one must have inside, something one must have in their head, and not something that must be stipulated in the law. And this can be achieved by improving training, improving selection, and improving accountability of judges. In Ukraine, compared to many European countries, Ukraine enjoys high levels of transparency in courts. A Ukrainian citizen can video record a court hearing. The assignment of cases in Ukraine is automatic, and again, this is something absent in the Dutch practice. But what matters is the judge's attitude. If a lot of judges aim to circumvent this system of automatic case assignment, or if judges are no longer afraid of video cameras, and if they if they brazenly violate the law under CCTV, they have a feeling of impunity. Then, I'd like to talk about the service orientation of courts. Courts are perceived as an institution with the head of the court and the people who come to the head of the court, and that is the head that settles a case. But in fact, the court is an institution that is intended to serve society and to maintain order and preserve and do justice in society. Right now, it is difficult to call a Ukrainian court service-oriented. The court procedure is a lot of the time vacant judge positions in Ukraine are not filled. The reform led to the fact that a third of the judges corps resigned, and that leaves a lot of unfilled positions, and a result of which people are suffering because their cases are not being heard in due time. Time management in courts, when monitoring court hearings, we see that every other 50% of the court hearing schedule does not take place. People travel long distances to take part in a court hearing, but it is often sabotaged, either because the counterparty did not show up or because the judge failed to show up to court. There is a need to institute a system which would inform the participants of the trial beforehand about the fact that the court session will not be held, so as not to waste their time. One thing we saw in the Netherlands is that courts resembled huge supermarkets where with a helpful reception counter where people were treated well, and this is a stark contrast with Ukrainian courts where visiting a court turns into a Kafka-esque procedure. Vadim Valka, I'm sorry for interrupting you. He published an article about analyzing NABU cases against judges. I think again 40 cases against judges, And there's a price list in Ukrainian courts in every category of civil, criminal, economic, administrative cases on the bribes. And this, you can look this in the case, I think starting from $26,000 and going up to going down to 5,000 cases. It's a very interesting piece. I'm sorry for interrupting you. Yes, indeed. Sadly, Ukrainian courts, Ukrainian citizens perceive courts as institutions that trade, that sell justice instead of and there are a lot, our Ukrainian courts are not sufficiently service-oriented. There are certain courts who have considered this issue and have started working on making a court a comfortable place for a visitor, where a person can have a glass of water, can charge their mobile phone, where the user is given small signs and significant signs of attention to improve the people's perception for the activity of the courts. And
now we speak about unsecured until that time possibilities to settle disputes without attending physically the locations of court hearings. Today, due to numerous reasons, this opportunity has not been yet validated, but that presents a new challenge for the new power through e-justice, a possibility to communicate with court without leaving your house. And another point is communication. Following USAID's data, no justice, we can track that the level of trust to the courts generally is low. Against these cases where physical attendance to the court is secured. 34% is not that high stake against the Western countries. In the West, this stake is higher, and there is a confirmation that the level of justice is indeed fair, and the rate of trust of the general public to the court appears to be also stronger against that level that the Ukrainian today fix. We can track slight difference, since the expectations are indeed very low. We can see that at some point these expectations are slowly lower. And speaking about the justice, we need to secure those indicators that prove performance of courts effective. Following the recommendations that we issue based on this study, highlight necessity to implement methodology that is essential for proper communication among all court stakeholders. Our Dutch colleagues were struck with this fact since the Council of Justice makes it their ultimate mandate to attend institutions and 3 times per annum to collect information, and 3 times per annum to secure these receivables. And it's not only about trust that is a criteria to assess. Here it goes about good name and reputation, apart from performance, fair justice and a service-oriented approach, etc. This information is being collected across different groups of the general public, and a variety of communication tools are normally deployed. For children, we use some selected instruments, and for age group there will be it's a specific methodology chosen with a view to the specifics of target groups that are to be covered under this framework. We can make a note saying that communication over the past 5 years has grown significantly. There is big success in terms of informing the court enforcement institutions. Then information is shared on the part of PR secretaries, and other interlocutors also tend to bring across the information that is being harvested. Speaking about production of a variety of materials, we face problems with the quality. Quantity of data is not an indicator that will signify effective performance in question. We need to assess advisability of key products that should be appropriate for each target audience. What's indeed critical is that courts should communicate information in such a way that will enable bettering the system of justice. When the system of justice appears to be better, then we will have to communicate such information in a more efficient way. The ultimate goal is to ensure that such information is sincere. Employees of the system of justice from the Netherlands proves that in case of disseminating positive information, that at the background of these developments will be perceived negatively, will be a marker of deceit. Another thing that's also important is that the communication should be active. When the publications that are in place are modified, the Council of Justice today tends to collect the information, considering the transformations that are underway. Again, what bottlenecks are they about to resolve? Speaking about the courts and their intention to resolve those issues that are up, the court injunction should list bottlenecks to be dwelled on. Speaking about this novel, this is a new practice that was communicated to us. In many respects, it's indeed useful for us to be able to bring it to the ground here in Ukraine. And another thing is to play in the framework of the context that underlies the current developments. I would like to come up with a brief on very simple, non-complicated arguments. Court injunctions today imply a list of certain resolutions, conclusions, and injunctions that are based on the current legislation. And that also poses another question: why did we encounter such a resolution? Speaking about dispute settlement, I would like to state that some recommendations can be issued so that the information could be obtained not from stakeholders, but directly from courts. Then trust towards courts as a problematic issue will be up, and we will approach this agenda with a new approach. At this, I would like to extend my gratitude to the Center for Economic Strategy and thank all the co-authors. And another thing is the Center for Economic Strategy would like to organize such like events in the future. In terms of the document that is in place, I would like to state that more recommendations will be collected later. Before handing over Mike to Lina, when we attended the Netherlands twice, the experience that we reached proved that trust to the system of justice should grow. And speaking about the assessment from the local citizens, that no complexities are in place, and there is a possibility to live another 100 years. There are lots of traditions that will be governing for that. Starting with construction of premises, down to maintenance of buildings. Considering that the list of customs that today govern the current practices will provide a response to top 3 recommendations that should be issued to raise level of trust to the courts. You're absolutely right saying that the historical background and geopolitical location of Ukraine fosters parity among Ukraine, the Netherlands and other countries. So this experience is rather relevant, approaches are identical. Speaking about authoritative regime, it is in place. For hundreds of years this system was fostered and no struggling was noted for the independence of justice in these countries. Speaking about attitude towards the system of justice, I guess that battles are indeed doubt, and most probably we should seriously renovate the skeleton to enable attainment of mutual understanding and bringing across proper messages to the pertinent stakeholders so that the system in place could be secured. And at present, this constitutes critical suggestion, and to some extent we can mark certain steps towards advancing requirements to judges, since positive signals of their activity are noted. Positive experience that has already been evaluated as positive, and where international experts will be tuned in. Following the recommendation of the highest qualification commission, prove that the highest body, the High Council of Justice, will serve as a driver of reforms, meaning the current system of justice will be brought to its modern shape. For multiple years, without bringing to responsibility where some open violations were spotted. For the courts that appear to be very convenient, I guess that can serve as a leverage of security in the modern world. And this I would like to extend gratitude for the preview, since I myself explored the document and I issued my feedback note about public reports, and I guess that Lina has something to add and comment on. Please tell us whether you agree to what we wrote before and how this can change the current developments. Whether it's possible to do something to raise trust towards the system of justice.
I would like to thank the organizers for organizing this event here in this beautiful hall. And maybe as a second point, I would like to stress that I represent the Center for International Legal Cooperation, which is a Dutch not-for-profit project organization that designs and implements rule of law projects and programs in various countries in the world, always countries in transition. So I do not represent the Dutch judiciary as such. That means what I will say is not said on behalf of the Dutch judiciary. But on behalf of my organization, and I think my experience in facilitating projects on strengthening the rule of law in the broadest sense in various countries in Eastern Europe and Southeastern Europe, including in Ukraine. I'm happy to be in Kiev. And I think if I look at the extensive presentation of Roman, I can be a bit more brief about the report. I think that this research paper that was drafted touches upon a lot of issues in the justice sector in Ukraine, and oftentimes the links there are references or links made to the Dutch state of affairs, which often is quite different. There was a lot already said about the differences in the histories and the social development in our countries. So having said this, I still hope to be of relevance here this morning for our discussion. It's I think as a sort of a first content remark, I'd like to stress that in my view, an open and transparent system of justice is a precondition for establishing and maintaining public trust in justice, which is a cornerstone of the legitimacy of the judiciary. And a proactive attitude of the judiciary itself, I think, is indispensable for promoting understanding of the judicial independence and respect for the judicial independence. I think the judiciary can take an active approach, an active attitude on this. In the course of this research, as already mentioned, there were visits to the Netherlands, and we tried to connect and link the researchers to practitioners in the Dutch judiciary to talk about the issues of the independence of the judiciary, and then the specific points that Roman raised this morning in relation to the selection procedure of judicial office holders. Sorry, the link between their work, the communication about their work, and the trust and confidence of society in general, and specific stakeholders in particular. I can maybe add that measuring and analyzing public confidence is something that the Council for the Judiciary in the Netherlands takes very seriously. Every 4 months, this Council for the Judiciary reports about the developments in public trusts, in sentiments, in social and mainstream media, complaints, web data, etc. And it also conducts a questionnaire every 3 years measuring the components that contribute to public trust among relevant stakeholders, so the prosecution service, lawyers, court users, and also media representatives. Now, these reports and surveys and survey results, they are shared with court presidents, with media judges, and also with communication advisors and communication staff in the courts. So, as maybe an example of an active approach, there is something you can do. Maybe another thing I would like to add here is that maybe it's more in the sort of a disclaimer a little bit, because and something in defense also of the in-office judges and other judicial staff in Ukraine. In my view, the circumstances in this sector are not easy. There is a considerable high workload, in my understanding, in all courts, and there is the uncertainty of the reform of the judiciary, and specifically the reform of these courts with reassessments of in-office judges, etc. So high workload and uncertainty in the sector. And I mention this because I think it's directly linked to aspects of procedural justice, which in my view is very closely related to public trust and confidence in the judiciary. What do you expect when you go to court? When people who have a disagreement and at some point feel that they cannot solve this, and they bring it to court expecting that there, in an open, transparent, impartial environment, they can present their case, be heard, and then ultimately you ask the judge to take a decision. Judges are the decision takers. Now, if you take this into account, you go to this court as a sort of a last resort to solve your conflict. What you would like, I think, is to see that this court attributes time to assess your case, to talk to you or your legal representatives. You do need the feeling that you are heard. Now, if judges here have 40 cases per day on average, I think it's a challenge for them, in my view, to make everybody feel that due time is taken to consider all the cases. So I do see a link with the high workload and the aspects of procedural justice, and I think linked to this also may be relevant to look at the core task of a judge. The core task, Roman already mentioned that indeed in the discussions in the Netherlands, we seem to see a sort of a difference in the, I would say, approach maybe of judges in both our countries, where Ukraine indeed seems to have a rather legalistic approach. So I have in my contacts or in discussions with judges in Eastern Europe, I often hear judges say that the answers to all possible questions can be found in the law, and I always it makes me wonder, because judges, not everything can be in the legal framework, can it? And judges are the authority. They have the vested authority to make a decision in the situation of a conflict. If we look at civil and administrative law, or in criminal law, it's the same. They are there to bridge the gap between the norms of the law and the facts. So if you do that, you will need to reason your decision, and this is something that I think it's again something of a something that can be be taken into account when courts want to work on establishing and maintaining a higher trust from the public. Give due time for a judge to do his or her work, to explain how you come to a judicial decision. Earlier in the morning we hear that justice delayed is justice denied. You also have this famous saying of justice must not only be done but be seen to be done, but there is another level, and that is, I think, in my view, that justice must be understood in order to be accepted. And there is the link with the authority of justice and the legitimacy of justice. So a very long, sorry for this long introduction. You will have to repeat the question again, Mihailo.
The question? I think the question was, how do you see this from your perspective? I think you pretty much answered that. If I may, then I would ask you, you mentioned workload and the ways also our judicial systems are different. It's not the first time that you're in Ukraine and you've dealt with Ukrainian courts and you had projects here, you visited some of them. What is one thing that strikes you the most probably? What is the difference? Is there one thing that you can mention that you said, look, if they changed this one thing, the level of trust would be different? Or how can they have this and still try to, gain trust or something? Is there any striking difference, really? Probably it is. What is that one, or two, or three?
Yes, that is a difficult one. In the initiatives that I work on in Ukraine, I try as much as possible to stay on the working level and to look at the practice of work in the justice sector here with the legal practitioners here, together indeed often with Dutch colleagues, to assess what actually are the stumbling blocks or the problems on the working level, to see if we can then generate attention at a higher level, that certain things might deserve some attention. So this I don't have any. I cannot say now, like on a broad scale, this and this should be changed. I do have an example though of something I think small. Ukraine has in 2016, if you allow me, in 2016 a law was adopted here in Ukraine on formulating a probation service. So in criminal law, not everybody, prison is not always the right answer to certain crimes. And there is now a probation institution, it's called Center of Probation in Ukrainian, which has an advisory role before the hearing. So this institution can have, after a suspect is apprehended by the police, have an interview with this person to look at the various aspects of the life of this person, to try to find the core, the root cause of criminal behavior in this specific case. Now, if you don't give that institution, if you give that institution only 10 days of time to come up with a useful report, you might not get all the benefits that you could get. So in that specific project, one of the suggestions we would like to make to the Ministry of Justice is, if please extend the time frame for this institution to deliver this so-called pre-trial report. This is very much off topic. It was just an example of how, what the level is of the work that I do with my colleagues here. But maybe we should get back to the trust.
Sure.
to the trust in the justice sector.
Then my question would be my probably last question before we open the discussion and questions from the audience. Roman mentioned that probably his suggestion, his number one suggestion would be then to, and this is something quite honestly that we very much concentrate on, the judicial governance bodies. So for us this is the key, how you select judges, how you discipline them, what contributes to the career of a judge, who decides, and obviously you can't have a very trustworthy judiciary if you don't have trust to the bodies that select judges, and if their decisions are flawed, and if they don't select good judges to begin with. Do you think these suggestions to renew these bodies and also to include non-judges, to include those to whom the society has higher level of trust, so by that increasing the level of trust to the quality of the decision making, very probably, hopefully, in this judicial governance bodies, is this the right way, you think? Is this something that we, from your perspective, is this something that would contribute to increasing the level of trust?
Yes, I think I can say yes. I do think that a balanced system of the selection of judicial staff is essential. Yeah, and I do not claim to know what is the right road for Ukraine, but I do think that there is a lot of experience, not only in the Netherlands, because it seems now I get the feeling that we have a kind of a rosy image of a shiny, everything perfect. That's not the case, obviously. But next to the Netherlands, there are many other neighboring countries. Europe is bigger than Ukraine and the Netherlands, and there are a lot of countries that we can look at. And maybe in this respect, it's also good to mention the work of the network of the councils for the judiciary. That's a European sort of an umbrella organization of councils for the judiciary. This organization also performs researches, has projects also about public trust and confidence in the judiciary. So that's maybe also something to look at. But to your question, yes, a balanced selection procedure to me seems essential. Yes.
Thank you very much, Lino.
It's an uphill battle. So if you have questions, please raise your hand, introduce yourself, and please give the name of the institution you're representing. And if you're asking a question, please specify which panelists the question is addressed to. And let's... Okay. Good afternoon. My name is Christina Prechodko from the Center for the Development of Innovative Development. I think, thank you very much for both extremely informative talks, but I'd like to ask Roman, Mr. Roman, what do you think? Are there the instruments and the courts, how can they address the issues you've mentioned? What instruments can address the issues you mentioned? Electronic courts, for example, and if you're talking about e-courts, what do you mean when you say e-courts? Thank you very much for the question. One of our key proposals was to develop this instrument. We have elements of e-justice in Ukraine, so online you can pay for court fees, and we have an online personal cabinet as part as the e-system, but sadly this system has come to a halt. We were about to launch this. We even had a newspaper piece about the kickstarting the publications process, but before the date of the launching of the process, it was repealed in the last minute. I think that e-justice is about the ability to communicate with the court without leaving the comfort of your home, to have online hearings when there is no need for you to be personally present in the court. And I think there's a lot of cases like this where number two, this decreases the costs, so people no longer have to travel long distances to make it to a court hearing that might not even take place. And of course this will lead to a dramatic decrease in the consumption of resources and also accelerate the court hearings. Most court summonses are sent out by mail, by post, which is of course a colossal waste of time. In the longer term, you could talk about the fact that certain cases could be heard with the help of artificial intelligence, and verdicts could be made with the help of artificial intelligence. For example, when there's consent of both parties in, for example, court rulings. I saw a very interesting initiative in the Netherlands when family disputes could be resolved with the help of an online system which acts as a mediator. And it's not an actual physical person mediator, but it's a system that allows you to communicate, for the sides to communicate who do not want to see eye to eye on both the metaphorical and the literal level, and but they can also tell the system what they need when resolving this dispute. And I think this has colossal potential, and I think this can significantly improve the people's perception of the activity of the judges if they would be the first to implement these cutting-edge IT technologies. I see how well the system works in the provision of administrative services, when administrative services can be accessed online with the help of the citizen's digital signature, and this takes place quickly and easily. I think this will allow us to take a part of the workload of courts when we see these huge lines to enter the court of law, and so on and so forth. Thank you, Mr. Rahman. Thank you, dear colleagues. I have a question. Mr. Rahman, thank you for your speech. Natalia Mamchenko from the Court Legal Gazette. You say that a lack of trust is a result of a large amount of parties not showing up to court. So the lawyers or the prosecutors don't come to the hearing, they sabotage the hearing. How do you think this issue could be resolved? We've heard of the higher council of judges to think of an code of conduct to make sure that there would be a penalty for not showing up to court for an attorney or a prosecutor. Do you support this initiative, or do you think there are other alternatives to make sure that the parties actually make it to the hearing? Thank you for your question. I don't think this is only a question of liability and accountability. I think that a lot of hearings are sabotaged or delayed because the judge doesn't show up to work on time, and this is a regular pattern of behavior for this judge, and these judges remain in office despite their gross violations of procedural code. It's not only the parties sabotaging the hearings, but the court itself can sabotage hearings. I think in many cases this could be addressed by informing the parties. So a party says they will not attend and informs the other party that the hearing will be postponed, so as to avoid people traveling long distance in vain. Another way to address this would be to impose liability and penalties for the parties, but sometimes an attorney could deal with multiple processes simultaneously, and they could physically not have the time. So it's about coordinating schedules, and it's also about the accountability of the parties themselves, that they are unable to provide for their legal representative as attendance in court. This should be the problem of the party and not the problem of the trial as such. thank you for your presentation. My name is Valeria Han. I am from the Human Rights Vector NGO. We've talked a lot about communication in judges, that it's the fact that judges need to communicate in a clear manner positively affects their trust, but I think it's about how can you engage the civic sector and the NGOs in shaping the communicative policy of the courts. And this is a question addressed to all the speakers. How do you think these positive practices that NGOs develop, how can these practices be communicated to the courts or to the judiciary? For example, we've talked about studies and surveys, polls, and so on. Is there a way to engage NGOs in the communicative system of the judiciary, the communications committee of the judiciary? So how can NGOs help impact this? What ways do you see to address this issue? Thank you. I think the question was addressed to both speakers. So Mr. Rahman, during the translation stage.
I believe that it goes about mutually interesting cooperation and reputation alongside with good name of the system of justice in the Netherlands and liaison with the universities that are accountable for elaboration of certain methodologies and conduct of studies and research about addressing courts and modernizing the current system of justice. I believe that these initiatives are indeed tangible for Ukraine, and these that have been already working to advance this mainstream in quite a lot of cases will appear to be rather effective, since a number of NGOs that today provide enough information to the society, and if content of relevant nature is there, meaning positive transformations, and this implies that communication can be of a quite high quality, and you shouldn't expect till someone will extend the weight of pride to you. Well, you should understand that the job you do is a quality job, and then the pride will arrive as such.
Thank you. Yeah, I had to listen to the last part of the interpretation. Thank you for your question. I think that in general, NGOs and civil society actors in any country play an important role. The judiciary here maybe could ensure that its radar is tuned well. Sounds maybe a little bit strange, but I think NGOs can be interesting organizations to be in touch with for communication advisors and communication staff, because they can very clearly present the sentiments in society and bring to the attention what are resounding cases. You need to have a radar for this. Yeah, so I do think you can. I do not have an answer on how to structure all this, but I think an aligned communication strategy for the judiciary should be the starting point, or could be a starting point.
Colleagues, we are short of time. Should you have any questions, please raise your hands. We will collect questions and we will respond to your questions on the post. Many thanks for such a vivid discussion, and enjoy your coffee and tea, please.